The basis for the child's motion to join PhD and the basis for the court's order was a children's court rule that supposedly permits the court to join any person as a party to an abuse and neglect proceeding, but that actually has a much more limited purpose than that. The court ordered joinder, even though no provision of the Children's Code provides for joinder of a health insurer or a health plan in an abuse and neglect proceeding, even though no case law from New Mexico or apparently from any other jurisdiction suggests that a health plan is a proper party to an ongoing abuse and neglect proceeding. Even though there's no scholarship, legal scholarship, or knowledgeable commentary that, including the leading treatise on child welfare law in New Mexico, that seems to envision such a maneuver. Even though child had no claims against Presbyterian Health Plan that were cognizable in children's.
So how would you suggest that? I know one of the concerns from the opposing side is making sure that things like treatment foster care and other things that Presbyterian ultimately would be in charge of is done timely and effectively. How would a court go about making sure that's done? Because ultimately the court does have to decide what's in the best interest of the child, depending on what stage of the proceeding it is. And I don't recall specifically for this one, but overall, that's an overarching thing. And part of that's making sure they have the care they need. How would a court go about doing that?
Yes, Your Honor. And that is a matter that has been entrusted to the single state agency. That's the language of the Medicaid Act, which here in New Mexico was the Human Services Department, now the Healthcare Authority, Healthcare Administration. And what the HCA has done, as the single state agency has in many states, is to confine those kinds of questions about delivery of services to an administrative proceeding, first of all, an internal proceeding with the Presbyterian Health Plan. And there are state regulations that are very explicit about how that has to be done, how it has to be done in a timely fashion. Once the member has exhausted.
So I was a little surprised, quite frankly, on both sides that this was not stressed more. As a trial court judge, I handled these benefits proceedings. It seemed like a benefits proceeding appeal. I quite frankly it seems to me this is a benefits appeal that would go, the aggrieved would be CYFD or HSD would tell press what to do. Press would say, we can provide that service or not. And then they take administrative appeal to district court. And then there's an appeal of that. What, if that is true, if you accept that principle, how does it bear on the question of whether or not, either under our rule of joinder or the children's court rule, would prohibit the joinder of press? What is it about this in case law? Is it exhaustion? What prohibits joinder?
Your Honor, it's a few things. It is the doctrine of exhaustion of administrative remedies. The single state agency that Congress has said is in charge of administering Medicaid in New Mexico, and the New Mexico in turn has designated to do that, has said that benefits decisions are to be determined in this administrative proceeding. And by the way, this wouldn't be just an administrative appeal because it was never argued to either forum in the first place. So there's nothing to even appeal from at this point. But that's one way, Your Honor.
But did any beneficiary go through, did press, for example, claim that they were aggrieved by an agency decision to provide a benefit? All I read in the record is press is saying, we can do this. It's just, we can't do it under this timeline.
Your Honor, Presbyterian has never claimed that it was aggrieved. It has always stepped up to the plate and tried to provide the services that child's therapists and other medical professionals
So
have
if
said,
press doesn't trigger that, what would be the exhaustion then? If you're relying on press to trigger that, if press is aggrieved, how else can this process work up to for this exhaustion to happen?
typically what happens, Your Honor, and what should have happened here is child should have filed an appeal. Child was aggrieved before, it says that he was aggrieved before and should have presented that to the health plan in the first instance. And the reason child was able to do that is that there are regulations saying that an adverse benefits determination includes a failure to timely provide services. And that is apparently what child is complaining about.
In this instance, could the children's court, consistent with your position, could the children's court judge have kind of lowered the boom, so to speak, on HSD if the argument was that HSD's relationship with press and that contracting was somehow faulty? Could HSD be the party that the court says, you know, I'm going to keep my thumb on this and I'm going to pay attention to what's going on by bringing HSD in as opposed to PhD?
Well, the court has done that in this case. I'm not.
But is could doing that still be consistent with your position that your client doesn't have the direct relationship with child? HSD has a much more direct relationship with child. Could we carve that out and be consistent?
I would say that HSD has a direct relationship with Presbyterian Health Plan. That's where the contract duties flow between HSD and Presbyterian Health Plan.
Does
HSD
have any duty or responsibility to child?
HSD does.
So that's what I'm saying. Why can't the children's court pull in HSD and say, you better figure this out, not pull you in because your client's one step removed?
Yes, I mean, if the children's court is to put pressure on any party, I think HSD is the appropriate party. Now, I'm not here to argue whether that joinder order was appropriate in itself.
I just, if one is out of line, is it categorically that both are out of line? I'm trying to test the parameter.
Thank you, Your Honor. No, it is not the case that, and you know, if Presbyterian Health Plan were resisting a recommendation of child's treatment providers and refusing to provide a benefit, and HSD thought it was a benefit that needed to be provided, then that would be a subject of a contract action between them. Or if children's court thought, I suppose in this case, since HSD has now been joined as a party, children's court thought that PHP was sluggish in providing services, and that HSD wasn't doing enough about it. I guess in this case, the children's court could impose some pressure on it.
And as I understand that the children's court judge rationale was, well, I want to keep an eye on this and, you know, make sure things are moving along. Isn't that equally accomplished? I guess I think there's an argument for you. It's equally accomplished by having HSD in. You don't need both HSD and PhD to accomplish that.
Well, I think that's right. I mean, the joinder order, it sort of embodies the philosophy of, you know, keep your friends close and your health plan closer. I mean, you want to have the health plan always there in case anything arises. That's the theory behind this joinder order. And yes, of course, if you had the health plan directly there as opposed to HSD, then it would be more efficient, but at the cost of due process.
I don't know if it would be. I mean, there has to be a lot of these claims out there. Would we be establishing a precedent which you can run right to district court? I mean, there are a lot of beneficiaries under this form of plan or other benefits, state benefits. I would imagine you would be concerned with direct access to a trial court to address the right, the need to those benefits. Those were always the things that were discerned at the administrative level and then came up to us for review. It just seems like this is a rule, would there be any other barrier to direct access to the district courts for a denial of benefits?
I mean, that is a concern, Your Honor. I think the hook here is this best interest standard, and I didn't finish addressing Justice Zamora's question on that, so let me see if I can do that. I mean, what the theory here is that I think Child concedes that it would be absurd to construe this children's court rule as giving the children's court authority to join just any old person. But Child says—
The rule says, it doesn't say old,
it doesn't.
but it says any person.
It does, but it—
Which I appreciate the answer.
I'm of that age. So I mean, the theory here is the limiting principle, Child's limiting principle is the children's court can join anyone in whose best interests someone should be joined. And the problem with that theory is that best interests is not an abstract standard to be compared against all other interests in the world and to prevail whenever they're in conflict. What the best interest standard is very narrowly focused on custody decisions, placement decisions. And that is that's the core jurisdiction of the children's court. Those are the decisions that the children's court has exclusive authority to make. Those are the only decisions that the children's court has.
But whether to leave a child in long-term residential care or treatment foster care, and when that should happen, is directly related to placement.
And that is the argument of Nietzsche, Your Honor. And I think the problem with it is the Presbyterian Health Plan is not resisting the idea that Child belongs in treatment foster care and wants to provide that benefit. Practically speaking, it has been difficult to provide it as soon as Child needs it and believes it to be necessary. But that is not a custody law dispute. That is a contract law dispute, if it is anything.
So let me ask you this, is it possible that if the court wanted information, and I believe Presbyterian's person is either called a treatment coordinator or a care coordinator?
Yes. Yeah.
Okay. Is there any reason, if this information was so important to one of the parties or the court, that they couldn't subpoena this person to testify about what efforts?
No reason whatsoever, Your Honor. That's what we suggest would have been appropriate if the court had wanted to twist arms, bang heads, whatever the court, the euphemisms that the children's court used in this case. Put that person on the stand and call that person to account if you're going to do anything. That's, we put people under oath that we want information from. We don't make them parties.
So our challenge here is if we, regardless kind of who we end up agreeing with here, we need to craft something that is principled. It can't be 100, I don't think it can be 100% your way or 100% the respondent's way. Because one is anything and one is nothing. So what principled way do we craft a rule for a children's court so we have to also be careful about unintended consequences. I sat trying to think of a scenario where it would be appropriate to bring a healthcare provider in that's under contract with HSD. There could be a time where that is necessary. So what's the principled rule that we should be crafting as a result of this case to guide courts in the future that doesn't foreclose what's necessary, but also isn't open to, the garbage man? I'm not suggesting that that is the argument of respondents, but.
Your Honor, I think it's important to look at the language of the rule here and make sure that that we're on the same page about it. And the way I read the rule, at least, is that it does not say that any person may be joined to an abuse and neglect proceeding. What it tells us is that the parties to a neglect and abuse proceeding are CYFD, the allegedly abusive parent or custodian or guardian, the allegedly abused child, and any other person made a party by the court.
Mhm.
Now, what does any other person made a party by the court in that context mean? And when you look, first of all, under the doctrine of the justum generis, we should look at the specifically used terms to determine the meaning of that general term. We don't construe any other person in its widest sense. We construe it in relation to the terms that have gone before it. And those terms all describe parents, guardians, custodians, relatives, state agencies with responsibility for the welfare of the child, and Indian tribes, those kinds of parties. So that's,
Mr. Purcell, in this case, the trial court used the standard necessary parties. So you're saying that's and looking at Rule 19A, is that a correct standard or is that an incorrect standard? Necessary party.
that's an incorrect standard, Your Honor, under
By
this,
your argument.
under this court's decision in State XRL CYFD versus Jamila
Okay.
B.
Another question I have is, you say there may be a contract dispute between the provider and HSD that should be litigated first. There may be an administrative appeal for a denial or restriction of benefits that should be litigated first and then appealed. Can you envision a situation where the best interest of the child cannot wait for that litigation to take place and those appeals to take place before he's getting relief that he's entitled to, maybe, and needs, maybe?
And that's, I mean, that is the appealing argument of the best interest standard, Your Honor. I mean, if we consider only the best interests of the children in children's court, then yes, in every situation where there is a right that can be asserted by the child against another party, and it doesn't have to be just a health plan, it can be anybody. If we're going to bring any party into children's court with which or with whom child has a contractual dispute or against whom he has a tort claim, the children's court jurisdiction is going to expand like topsy. And although it would be faster perhaps and more efficient, as I say, to bring the Presbyterian Health Plan in as a party and folks could jump.
So what happens to the child in the meantime? Sit around and wait for this litigation to take place?
It is, relatively speaking, an expeditious administrative process, Your Honor. And it is designed to be that way. It is not a years-long process of exhausting administrative.
You know, a month to a 12-year-old is a lot longer than a month to a 30-year-old.
It is, Your Honor, and again, that's when Justice Zamora's idea of bringing in the Presbyterian Health Plan representative, putting him on the stand and saying, "What's going on here?" I do want to emphasize, though, and this, in my view, this is all hypothetical because I think the evidence in front of the court, the children's court, and this court demonstrates the Presbyterian Health Plan was acting very responsibly the entire time, was trying to get child the benefits to which he was entitled, was stymied by various circumstances beyond its control. And I can go into detail about that if the court like, but I just want to make that point clear because I don't want to concede. That
Nobody's saying that Presbyterian is the bad actor here.
Thank you.
So I still don't think you've answered my question of what's the principled rule that we write? You were started down that
Yes,
path.
yes.
And I think what you were trying to say is that it has to, any other person has to somehow bear a relationship to CYFD, a parent, guardian, or custodian. So
Under that doctrine of justum generis, also under the official commentary on the adjacent subsection of the rule 121A, which says that, and the language of that rule is very similar. It says in a delinquency proceeding, the parties are the state, the child, and any other person or any person made a party by the court. And the commentary says that what that means is that the court has the power to join a parent or someone who by law can intervene. Rule 122 tells us who can intervene, and they are parents, guardians, custodians, Indian tribes, and the like, or anyone with the constitutionally protected interest.
So I follow that argument, switching a little bit. So these are our rules. We can do whatever we want to. This is not, you know, this is not statutory when we're talking about our rule 10-121, and the same for our joiner rule in district court. Why shouldn't we just engraft the standard for district court for necessary party into the children's court rules? Because then we don't violate we don't do any harm to our written jurisprudence.
This is a rule of the court, Your Honor, that's correct, but it must be informed, I think, by the Children's Code and by the limited jurisdiction of the Children's Court, according to case law in New Mexico. But the Children's Code also has something to say about this, and that is when you look in the Children's Code and try to find out who the proper parties are. And I realize that party status is a matter of judicial authority in many cases, but I think it has to be limited by the Children's Code. And the Children's Code says that people who can intervene in the case include, and it tells you who can intervene, and it says folks with a constitutionally protected interest in the dispositions of the Children's Court. And this is 32A-427. Certain relatives within the 5th degree of consanguinity, foster parents with whom the child has resided for 6 months, step parents, people who wish to become the child's permanent guardian. That is, I think, what the court should consider the limits of its joinder power, ultimately.
So I understand that, but our necessary party rule does no, I mean, that seems too limited. If I were to look at the Children's Code and say, well, if you fall out, who can, if we only limit this to who can intervene, we're missing people or parties that might be necessary for complete relief. And so why not engraft necessary for complete relief, which I think even pulling that into this would save your client, because I tend to agree your client isn't necessary for complete relief. HSD is. So and I don't see those two as incongruous.
I guess what I am pushing back on mildly, Your Honor, is the idea that the Children's Court has the power to grant the kind of relief that you're talking about. What the Children's Court has the power to do under the Children's Code is to make custody decisions. And here Children's Court is taking on the authority to either adjudicate contract disputes or disputes about violations of Medicaid regulations. Either that, or it's saying, we don't have to adjudicate them. We don't have the jurisdiction to do it anyway. We just want to twist some arms. I don't think that that is a proper use of the authority of the Children's Court, which has jurisdiction only over custody and placement decisions.
Thank you, counsel. 7 minutes.
Thank you.
Respondent? I'm sorry. Respondent, you have 30 minutes. You may enter your appearance.
Thank you. Good afternoon. Heather Hoaxed on behalf of the child Corey T. Sitting at council table with me is Austin Moore. Mr. Chief Justice, and may it please the court. Presbyterian Health Plan indeed does have a responsibility for ensuring that Corey T is provided clinically recommended and medically necessary services that support his health and welfare. Presbyterian's relationship to Corey is much more than contractual or a business transaction. Presbyterian is part of his treatment team and actively participates in decisions related to his health and his placement. It's not disputed that Presbyterian was responsible for providing the treatment foster care services that Corey was clinically recommended last year, nor is it disputed that Presbyterian continues to be responsible for providing physical and behavioral health services to Corey. The only thing in dispute here is whether or not the Children's Court rule, which is your rule, allows the Children's Court judge to bring Presbyterian into Corey's abuse and neglect case.
That is not a small dispute.
It's
It's jurisdictional. And quite frankly, again, argument by petitioner, I mean, it's more that, I know everybody wants folks to act in equity. I understand that, what is in the best interest of the child, but adding a party is more than just bringing a party to court. You have to have some connection to them. They have to be aggrieved. There must be some kind of injury or interest. And there's a whole administrative process to work out these disputes that happen all the time. Why would we ignore that process in this case? And if we do, and we write the rule you're asking respectfully, have we wiped that out? I mean, are we going to see in our district courts one contest after another for benefits?
I understand your concern, Chief Justice, and I have thought about this, and here's my response to that. The administrative process that Presbyterian is stating that Corey should have gone to is pretty inaccessible to Corey. Corey was never provided any sort of denial of service. He was never advised that he had administrative remedies. There was never an action that was adverse that triggered Presbyterian to send Corey or his legal guardian any notice of adverse determination. Presbyterian was not saying we're not going to provide this service.
HSD can, right? HSD can go to press and say, you're contracting with us to provide these benefits. You're going to provide it. You're going to provide it, or else there's a consequence under the administrative code, correct? HSD can do that.
HSD could do that, but again, that would not provide Corey complete relief. And the reason for that is that the main issue in this case as to why Presbyterian was joined and HSD was joined as well was the delay in services.
So you wanted the district court to order Presbyterian to timely provide services. So isn't it going back to what Justice Thompson said, Chief Justice is ultimately saying? Either the lack of providing services or the failure to timely provide services, which would go through an administrative.
I think that in this case and in children's court cases and abuse and neglect cases in particular, which are what we're talking about here. So I do not believe that any party could go into district court and avoid the administrative grievance procedure on Medicaid issues. This is specifically for a child that's in foster care in the legal custody of CYFD and receiving their Medicaid services through their managed care organization, in this case, Presbyterian. I lost track of your question. I apologize. How is it, what are we asking the court to do? It goes beyond simply saying, asking Presbyterian provide the service, Justice Zamora. And what happens in these cases, and in Corey's situation in particular, is that he was recommended for treatment foster care. He was sitting in the Peak, which is a acute crisis facility, been ready for discharge for over a month. No services being provided to him while he was there. No education, no meaningful therapy, because the Peak is designed to be a crisis unit for 7 to 10 days. There was nowhere for him to go because there was no treatment foster care placement in the state of New Mexico within Presbyterian's network that was available to him. And so what soon became apparent was that Presbyterian was going to have to look outside of their network. And Medicaid rule and law does clarify that should an in-network provider not be available, the Presbyterian is responsible for looking out of network. In Corey's case, that means out of state. And in order for a child who is in CYFD custody to be placed out of state, decisions have to be made that involve CYFD as the legal guardian, the youth attorney or the guardian ad litem, Presbyterian as the provider that's going to pay for these services. And those kinds of conversations are not going to be held in an administrative grievance process. So while an administrative grievance process may say, okay, Presbyterian, yes, you need to provide this service, Presbyterian still has to come to the table with CYFD and with the court.
But couldn't that be done if they were subpoenaed as a witness? Couldn't that conversation, because the subpoenaing them as a witness would allow the court to get that information or the parties to present it. Adding them as a party seems to take it a step further.
Yes, Justice Moore, they could have been subpoenaed, but that wouldn't have moved the issue any further because there would have been no mechanism by which the children's court could have said, CYFD, Presbyterian, you need to have a meeting and figure out how to get this child treatment out of state. If
District courts do that all the time. Yeah. I mean, they just do. But I think to not minimize what you're saying, is it your position that the children's court would have the ability to order Presbyterian to do something, like you're going to do this by next Monday? Would the district court have that power over PHP?
they would be able to do that if Presbyterian is a party to the case. And when you were asking Justice Bacon, what sort of rule would be in place, right? If you wanted to devise a rule that would more clearly state what type of party really does any person made a party by the court mean? Within the children's court jurisdiction are decisions related to the health, the safety, the welfare, the placement. It goes beyond custody, quite more beyond that, especially in abuse and neglect cases. So within that court's jurisdiction are decisions related to health, safety, and welfare of the child. Presbyterian is legally responsible and obligated to provide clinically recommended treatment and services that, in the case of treatment foster care, is also a placement to the child. And so the nexus is that this is a party that has obligations to the child that are related to his health, safety, and welfare, which is under the jurisdiction of the children's.
And clarify me for me, and then I may have a follow-up question. Child is being provided services by PHP because of PHP's contract with HSD. Is that correct?
Ultimately, yes, yeah.
So why can't the court pull the same trigger against HSD and say, I'm going to make you a party and I'm going to ride herd on you, HSD, until this is done to my satisfaction? Because HSD has power over PHP very directly through their contract.
Well, the reality is, Your Honor, that the court did join HSD.
I know, but why not HSD
only.
full stop? Because HSD, I mean, the court can say, I'm going to hold you in contempt if you don't figure this out by next Monday. HSD, because you're the one charged with this, and they're the ones entering into these contracts with whomever, and negotiating the terms and all of that. So HSD has a much bigger role in this from a more global perspective than just this one case.
Right, I understand that. I think that, HSD, part of the problem is more practical. And HSD ultimately is the Medicaid service provider. They contract with Presbyterian
Or whoever.
or whoever. In this case, it is Presbyterian. But then Presbyterian in that contract agrees, I'm going to follow the administrative code that says what I, as a managed care organization, have to provide for the child.
Right.
And again, we're going back to the issue of which Presbyterian wasn't saying we're not going to do it. There was no time when they said, we don't think we're responsible for this. We're not agreeing.
No, it's just, we can't fight.
It's just,
Figure this out.
and the problem was that from the child's perspective, actions could have been taken by Presbyterian to make the access to the treatment foster care placement more timely. That was the bottom line, that there was more that Presbyterian could do There were multiple meetings held and Presbyterian sent a care coordinator. That person did not participate in the meetings, never answered any questions, never had any ideas, but was there.
But aren't you at that point like foregoing the hammer that is HSD's power over PHP? I assume they have the power to withhold payment, to cancel the contract, to do a plethora of things that PHP would not want them to do. So isn't it more appropriate to have HSD being the one, instead of the court hauling PCP in and saying, you better do this in this case, HSD is the one with the real power to say, if you guys don't take care of this, here are the consequences under our contract, and we're gonna, if we get held in contempt, you're coming with us. Why is that not the more appropriate pathway?
The answer I would say to that is because of the direct relationship that Presbyterian has with the child versus HSD. Because of Presbyterian's responsibilities for providing the services for the child directly, that could HSD order them to take some actions or threaten to in the contract? Sure.
But HSD is the one with the hammer. The child doesn't have the hammer.
The child.
The child can't sue PHP, then go through the administrative proceeding. HSD is the one that can say, if you don't, here's what's going to happen, and it's going to be big. Why is that not the more appropriate?
It goes to that issue of the services being provided timely and the actual practical amount of time it would take for HSD to go through whatever procedure they would need to with Presbyterian.
If the court's saying you better take care of this by Monday or I'm going to hold you in contempt, HSD is going to have some impetus to get it taken care of.
Perhaps Justice Vargas, I would say that doesn't obviate the need for Presbyterian to be involved directly.
Can I ask you one thing that's been concerning me, even assuming that I agree with you that Presbyterian could be joined as a party? Does that mean it's just never ending? Because that's the way I'm construing the district court's order, that basically Presbyterian will be a party for the life of the case. And not only has this case gone on for some time, there's cases that I think last over a decade.
Yes, this case has gone on for 9 years, which was part of the reason that the Children's Court took some action. But no, there are mechanisms for Presbyterian to be dismissed, and the joinder, with 10-321 does provide that a party may just be dismissed upon the court's action or upon the request of that party. So Presbyterian can at any time file a motion.
And what is the argument press offers? It's not a legal argument. It's that what? How would they get out? We are no longer, the messages of the child is no longer engaged by us being in this?
No, Justice Thompson. I'm sorry, if you'd like to finish.
Well, ignore that question. Aren't we suggesting, and tell me if I'm exaggerating, aren't we in effect saying, it seems to me, you want HSD to do their job, tell press to provide these services. HSD is not doing that. So I want the court to tell them to do that. And in effect, aren't we just substituting the court for HSD?
From the child's perspective, no. And again, I just keep coming back to the practicalities of the case and what was happening at the time that HSD and Presbyterian were joined. And the fact, again, that the Presbyterian was involved in the meetings, involved with the treatment coordinator, but not taking fast enough action. And so to have a court order HSD to then tell Presbyterian to do things would just, in fact, Justice Vigil, you comment on this when you were speaking with Mr. Purcell, it would add more delay. And in the meantime, we have a child who's languishing.
So again, I'm going to ask a very similar question that I asked Mr. Purcell. What's the principled rule that we can write here? Because say I agree with your position, given the very specific facts of this case. We have to write a rule for all children's court cases. So what am I tethering that to? I understand you're talking about health, safety, and welfare. But that could be anybody. I mean, like, I'm going to bring in all the kids' teachers, their preschool teacher from 4 years ago, because they might have something to say. I'm going to bring them in as a party because it's related to health, safety, and welfare. That's really broad. And so the concern, I think, one of the concerns I have, but I think my colleagues do too, is that we're creating a system where PHP is going to be brought into every single case because of convenience of the district court judge to be like, do it faster, do it faster, do it faster. And that's not a rule. There's no principle language in that.
When I answer your question,
Yes.
because I've thought about it.
Okay, good.
But first, I also want to direct you to another section of the statute that can shine some light on this. So Rule 10-121B applies to two parts of the Children's Code: children in need of court-ordered services and the abuse and neglect statute. The rule that Mr. Purcell was alluding to is the delinquency code that does limit any other person made a party to the court to those allowed to intervene. That is not the case in the rule as it applies to children in need of court-ordered services and abuse and neglect. The children in need of court-ordered services statute in the provision on disposition specifically states that a district court can bring in a school district if it believes that there is educational deficiencies for the child. In other words, if the court says there's problems with education, and this makes sense because the children in need of court-ordered services statute often involves truancy. That many times how families get involved in that. So there's an issue with education. So the children's court is told that they can bring in
As a party.
school district.
That's statutorily provided for.
That is statutorily provided for. But the rules don't say then only a school district. The rules still say any other person made a party by the court. So in thinking about, well, why would the legislature say it's okay to bring in a school district? Well, it makes sense. There's educational concerns and issues. We're going to bring the school district in to do evaluations, I believe it says within 45 days, to ensure this child's educational needs are met. So the same sort of logic, Presbyterian has an obligation, just as a school district has an obligation on education, Presbyterian has an obligation around health services and behavioral health services. And so using that same logic, should the court be concerned that a child's health services, mental health services are not being provided and his needs are not being met, and Presbyterian is responsible for providing those services, let's bring them in so we can figure out how to make sure that these services are provided.
I follow that, but you still have this problem of the trial court can just say at the front end, you know what, I've had problems in the past with healthcare providers, so I'm just going to bring them in as a party now. What prevents that from happening without any principled limit on who's going to be added to the party?
I would say, Justice Bacon, that there would need to be an issue, right? So just because.
Why? Not based on this, I mean, granted, it's our rule, but why? Our rule just says, well, and anybody else the court thinks is appropriate. And to me, this is important too, because this raises issues in the guardianship world too, where we have the court gets to decide who interested parties are. I've always wondered, how am I going to navigate that? Here, there's no limit. It doesn't say once the parties bring a dispute about the healthcare provider to the court can make the healthcare provider, which you have with the school district.
That's correct.
We don't have that in this rule. And so there's no principled limit.
There's not now.
Yeah, but so what do we write and say to create a principled limit on any other person made a party? Because I think PHP's argument about that is too narrow, that it has to be related to parent, guardian, or custodian. Yours is maybe a little too closer, but still doesn't feel like a limit. Because I can make almost anything health, safety, and welfare.
Sure. I would argue there's an additional nexus in that the entity or individual, most likely entity in this case, would have to have some underlying legal obligation to the child. So just as a school district has an underlying obligation to provide education for the child, any other party, if they have an underlying obligation that involves health, welfare, and safety, which I understand can be broad, and bringing them into the case would further the best interests of the child within that health, safety, and welfare and placement, then that party could be brought into
So
the.
barring the question that Justice Bacon asked Mr. Purcell, is Rule 19 the correct test?
Children's court cases are very different from other cases. So whether Rule 19 is the rule to bring in, I'm not sure that I could answer that. I think that there are children's court rules for a reason. This court determined that there were children's court rules that apply and Rule 19 does not. And I would hedge a bet that the reason for that is because of the unique nature of children's court cases that sometimes involve unusual remedies. And so to have that latitude, this court has trusted the children's court judges to make decisions that are related to the best interests of the child. And that may go beyond the civil procedure rule, but can still be limited in some way.
So let's turn it around. Let's assume that the parties before the court, that given the parties before the court, complete relief can be granted. Would it make any sense to join another party that's not necessary to according full relief? It's flipping Rule 19 upside down.
Can you say that one more time?
So let's assume that the parties already before the court are sufficient to grant full relief to the parties. Does it make any sense to then forcibly make somebody else a party?
If the parties that are already in the case were sufficient to grant full relief, then no, I don't think that it would make sense to.
Okay, well, isn't that the standard under Rule 19?
Well, I think in this situation, and I may be confused by your question, and I apologize.
So Rule 19's focus is who are the parties necessary to afford complete relief?
Right.
And so here, assume with me that HSD is, and I know you're going to disagree with this, but say HSD is made a party, and we think HSD being a party will assist in affording complete relief, and we don't need PHP to come in as well. Is that a principled way to write the rule, to say that the children's court can bring any person can be made a party by the children's court as long as it's with an eye towards affording complete relief? And isn't that a principled way to write the rule, even though we're adopting from district court and
Right.
bringing it over?
Right.
Wouldn't that be enough, given that the best interest of the child is always going to be lying over that?
Maybe. I think what's also important, maybe why I'm pausing and hesitating, is because of how different every children's case is and how the facts are mind-boggling sometimes. And what has happened is mind-boggling sometimes. And so to allow the children's court judge to have that ability, knowing all of the facts of the case, the history of the case, who's important, who is necessary, under a slightly different standard than, say, in a standard lawsuit, if the child was suing HSD or suing Presbyterian, that would be a different forum, right? And different rules would apply. But in the children's court, having the discretion available to the children's court judge to make those determinations about who is necessary based upon the history of the case, what's happening now, what is possibly going to happen in the future, would serve children in foster care.
Have you had the opportunity to review Fisher cites in their case, a federal case, Graham versus Blue Cross? And if you haven't,
I have, to the extent that, if I recall, there's I believe it was cited for the purpose of the third-party beneficiary issue. Yes.
Does that analysis, is that holding bear on our analysis? Because, and seems you understand where you're coming from, but you continue to assert that press, they're in this, right? They're in the plan for the child, but they have an obligation on behalf of that child. They have this obligation, and I'm not sure, is there a contractual obligation? I don't see what obligation they have that is different from HSD. What, is there anything about that case in this analysis of third-party beneficiary that impacts our analysis?
Yes. The issue of whether or not Corey is a third-party beneficiary doesn't play into whether or not PHP is a necessary party to the case. If Corey were suing Presbyterian for breach of contract, which is not what's happening here, then that analysis would very likely come into play on whether or not he's a third-party beneficiary. But the obligation comes through, while it comes through the contract, because if there were no contract, Presbyterian wouldn't be sitting here today. They would not have any knowledge of Corey or what his needs are, but through the contract.
Corey was in the position of needing to sue somebody. Who would they sue? Would they sue HSD?
Presbyterian would say that would be his remedy. Under the New Mexico Patient Protection Act, an argument can be made that he does have third-party beneficiary rights. That's not settled.
Okay, that's fair. That's fair.
So he could sue Presbyterian. What the court would do to that,
I don't even know what we would do.
so that could be,
Yeah, that's fair.
So under your theory of Presbyterian being joined as a party, where does the authority of the children's court end? It sounds like they can order Presbyterian to timely provide services. If Presbyterian denies services, can then the children's court say the denial is improper and you have to provide, like where, now they're a party, where does the authority of the children's court end?
and that's a good question. And I think that looking at the jurisdiction of the children's court, and I'm going to go back to the school district analysis just because I find it helpful. So the court, or I'm sorry, the legislature clearly said a school district can come in, but that doesn't mean then that a children's court judge could find the school district liable for an injury that occurred at school, right? That would be outside the jurisdiction of the children's court. And so while that's not in the statute of what you can and can't do, the understanding is that the children's court can take actions and make orders that are in furtherance of the best interests of the child. Whether or not, if Presbyterian denied the benefit, the children's court could order Presbyterian to then provide the services anyway. That would probably be up for dispute. And a children's court could very well say to Corey, you're going to need to go through a different process for this if they're denying. But that's again not what happened here. And the other piece of this, I think that the concern of will Presbyterian be brought into every children's case? No. If Presbyterian is providing benefits timely and appropriately, there's no reason to bring them in. And the same as in Corey's case, they're a party now. The court found that they were necessary, but that doesn't mean that a year from now, Corey's needs have been met. Presbyterian still his MC, his managed care organization, but it's not necessary for them to be a part of the case anymore, as there's no need for push for services to provide it, if that makes sense.
Remind me when they were made a party.
Officially December of 2023.
So we're
Almost a year.
yeah, we're pretty far down the road. Is the child getting the services?
He's getting some services, yes.
So then it begs the question of why are they still a party?
Right.
I mean, other than to play, like overseer.
Right. They are still a party. There was a permanency hearing recently in which the court did order Presbyterian and CYFD to engage in some meetings to ensure that his needs were being met. And again, I'll go back to the rule on dismissal, which states that Presbyterian can file a motion and ask to be dismissed and present their argument to the children's court. We're providing everything timely. There's not been any issues. We haven't been asked to do anything. Dismiss us. And at that point, it's within the children's court discretion to do that.
Thank you, counsel.
Thank you.
Purcell, 7 minutes.
Thank you, Your Honor. May it please the court. I did want to suggest that I sense that Justice Thompson is frustrated by the lack of a more robust argument about exhaustion of administrative remedies.
I don't mean to express that.
And
It just, to me, there are rules behind bringing a party into court that are based more on all the equity we want to achieve in this case for this child. And I'm just trying to get at that. I'm trying to understand under our rules as a necessary party under 19, for example, what gives this court jurisdiction over press?
and I don't think there is anything, Your Honor. And what I was just
So I
going to say,
didn't mean to express.
no, that,
I look like that a lot.
what I meant to say only was this, that the best, I think our best argument on that is in the response to the amicus brief. So that's where I would direct the court's attention, because I think we explain pretty in detail why exhaustion of administrative remedies is necessary here. And it's not just state law, it's a federal law concept. But I'll leave it at that.
We like state law better.
So the argument is made that the children's court has authority to decide anything that concerns the health, safety, and welfare of the child. That is way too broad. And what I would urge the court to do is look at where that language is in the statute, 32(1)(3)(a). And it's very clear that when the legislature talks about the health, safety, and welfare of the child, it is setting those values against the competing value of family integrity. And that is the struggle of the Children's Code. That is what is involved in every placement and custody decision. That's the business of the Children's Court. And my view is that that's where it should be left. I realized when I was listening to the argument about HSD being a party and maybe exerting the pressure on Presbyterian Health Plan that is necessary, I was overlooking a very obvious answer now that is available under the turquoise care contract. And that is that CYFD is a party to that contract now. And CYFD is a party to every children's court proceeding. And so if there is a need to twist Presbyterian Health Plan's arm through arm twisting of its contracting parties, CYFD is an obvious choice for that role. It's going to be involved in every single one of these parties. In these cases.
I struggle with writing an opinion that says we're going to put more pressure on CYFD.
Understood, Your Honor. They have a very big job already.
They're struggling. I mean, there's no secret that it's not, it shouldn't be an elephant in the room. They're struggling to meet the obligations they have already. And for them to then for us to declare that they would be put in the position of overseer of PHP, seemed like a tough thing to put on them.
Well, as a practical matter, Your Honor, the Children's Court is always inquiring of CYFD, what are you doing to provide these services? Now, there was no time in this case, and we heard the argument, well, Presbyterian Health Plan just wasn't being responsive at all to this. There were meetings and the Presbyterian Health Plan representative said nothing. There's nothing in the record about that. And in fact, what Child said in his motion to join Presbyterian Health Plan and in the briefing on that motion was that that he was already familiar. He knew the care coordinator. There were daily placement meetings involving 24 folks from CYFD, Presbyterian Health Plan, and other interested parties. He said that Presbyterian Health Plan's representatives had already been involved in providing him with medically necessary services for years and will continue to be so involved. And he said that Presbyterian Health Plan personnel had attended his treatment team and planning meetings, been included in communications related to his clinically recommended services and procurement of those services, and had affirmatively responded to his requests for Presbyterian Health Plan's management to get involved in his placement. Presbyterian Health Plan was doing everything possible, and it still got joined as a party, a necessary party, to a children's court proceeding. And it is going to be permanently a part of this proceeding, because there will never come a time when it is not, until it ceases to be the health plan that provides coverage to child. There will never be a time when it's not convenient, as Justice Bacon says, to have Presbyterian Health Plan there, just in case there's some little delay in services. That is not a necessary party situation. And in fact, the controversy was moot even before this motion was heard. The placement that that child was requesting, the basis of his motion, was being made at that time. And yet Children's Court joined Presbyterian Health Plan as the party. Just a quick word on the Family in Need of Court-Ordered Services statute. That 10.121B is the rule that also applies to that statute. And I think it is significant that the legislature said you can join a local education agency if the child's educational needs are not being met. Said nothing about any other kind of agency. And that, I think, is why that Children's Court Rule 10.121B reads the way it does. It doesn't just say parties are these folks and anyone who can intervene. It says that they include anyone made a party by the court, because in that limited context, the court has the power to make a party to the court an agency that has to provide services.
All right, thank you, counsel. Thank you. Court appreciates the written briefing or oral argument in S1-SC-40347. The case is now deemed submitted and the court is in recess.